of the judgment because it captures everything I want to say nicely. In the headnote, it is this. It says, in Kazu, a mechanical horse had been leased to the appellant by the respondent. Appellant having fallen into arrears with his rental payments, respondent cancelled the lease and repossessed the vehicle. In terms of the provisions of the contract and for purposes of calculating the amount still due to the respondent, the vehicle was subjected to a final and binding, and that word is in quotes, final and binding, valuation by a sworn appraiser appointed by the respondent. In an appeal against a decision of a magistrate to the effect that respondent was entitled to payment of the amount thus calculated, it transpired that the appraiser concerned had assumed that the engine, gearbox, and diesel pump had to be repaired, that this assumption was not based upon a proper examination, and that only the engine itself needed repairs. Held, where the appraiser had wrongly assumed that the engine, gearbox, and diesel pump had to be repaired, he had not been properly informed, with the result that his valuation was arbitrary and not the judgment of a reasonable man. So he made an incorrect assumption. It was set aside as not being the judgment of a reasonable man. And so, my lady, whilst we accept that the cases, of course, are very different on the facts, they are illustrative of the circumstances which permit a court to intervene. My lady, we refer in this regard in our note to what it is, what is the understanding of the notion of acting unreasonably in our administrative law. And we refer in that regard, my lady, and deliberately to pre-constitutional jurisprudence, to what Baxter, in his work on administrative law, understands and describes as the concept of acting unreasonably. And we stress it for present purposes because everybody agrees, is that if one reaches the conclusion that the CEO was a valuer and that he acted unreasonably and that it resulted in a patently inequitable outcome, then your ladyship can intervene. And so, my lady, what Baxter does is he's got an entire chapter entitled Acting Unreasonably. And he first of all commences with what he describes as the three categories of unreasonableness. And the first category of unreasonableness concerns, and my lady, I'm reading from Baxter at page 496. It is in my references document. And the first of the three categories is where the basis for the decision is not in accordance with the evidence. He says this: if a decision is entirely without foundation, it is generally accepted to be one to which no reasonable person could have come. Here there is some overlapping between various kinds of unreasonableness, and he says, while the courts will set aside certain kinds of administrative decisions where these are supported by nothing at all, they will also set aside decisions which are complete non sequiturs on the evidence available. So I use the term, if there isn't an evidential basis for the decision, that is a form of unreasonableness. He then deals with a second category, which is related to purpose and motive. He says it is considered unacceptable for a public authority to use its powers dishonestly. Equally unreasonable, though, possibly less reprehensible, is the use of powers for purposes that are not contemplated by the enabling legislation. In both cases, the decision and the action taken in consequence of it will be set aside. And his third category, and perhaps it's the one with which your ladyship is most concerned, is the effect of the decision. And he says this: reasonable people do not advocate decisions which could lead to harsh, arbitrary, unjust, or uncertain consequences. Hence, it would be unreasonable to act in a manner that would have such consequences. The courts will review administrative acts in the light of their effects, and should these be found to be unreasonable, the action will be set aside. And milady, he then goes on to refer to the English cases. He says a perusal of the relevant dicta will reveal a welter of inconsistent terminology as judges refer to mala fides, improper purposes, etc. And he then quotes Lord Green from the famous and indeed perhaps the Bible of English administrative law, Associated Provincial Picture Houses versus Wensbury Corporation, in which Lord Green said that the various forms of abuse of discretion run into one another and overlap to a very great extent. They may satisfactorily be confined under the generic concept of unreasonableness. Now, milady, I'm going to return a little later to Wensbury's case once again, when I deal with the latest pronouncement from the English Supreme Court on this very issue. So, milady, that is the general understanding of what it means to act unreasonably. Can I then translate that into our particular case? And of course, my learned friend, Mr. Puckren, will go through each of the bases upon which we contend that the CEO acted either unreasonably or irregularly. I've already alluded to the fact that one of the bases for acting unreasonably is the failure to take into account relevant considerations or the ignoring of relevant considerations. Again, in the very chapter to which I've referred, Baxter devotes a great deal of space to that concept. Of course, milady, it is well known to your ladyship. So, if your ladyship finds that he took into account irrelevant considerations or he failed to take account of relevant considerations, that is a recognized species of acting unreasonably. And then, milady, another ground of review is one which is discussed also by Baxter in this very chapter, and that is the principle going back some 90 years and which is referred to in our heads of argument. It's based on the case of Patel versus Witbank Town Council. Lady, we refer to that in our heads in paragraph 53. Patel versus Witbank Town Council was decided some 90 years ago, 1931 TPD, but as we point out in our heads, it was endorsed by the SCA in the Rustenburg Platinum Mines case, and I'm going to refer you to an even more recent endorsement of it. But in Rustenburg Plats, which is, as I say, referred to in our heads and in my notes, I believe, if I could just confirm that I did give you that reference. Yes, milady, I've given you the reference by reference to our heads of argument.
Yes.
So Rustenburg Plat is in our heads.
The
Patel versus Witbank Town Council laid down this principle, and I'll just read it to your ladyship. It says, what the court in that case said is this: what is the effect upon the refusal of holding that while it has not been shown that grounds 1, 2, 4, and 5 are assailable, it has been shown that ground 3 is a bad ground of refusal. So there was a case where there were 5 grounds of refusal. 4 of them were okay, but 1 of them was bad. Now, it seems to me, if I'm correct in holding that ground 3 put forward by the council is bad, that the result is that the whole decision goes by the board. For this is not a ground of no importance. It is a ground which substantially influenced the council in its decision. This ground having substantially influenced the decision of the committee, it follows that the committee allowed its decisions to be influenced by a consideration which ought not to have weighed with it. So if I could just pause there, my lady, the principle is very straightforward and well known. If there are 5 grounds or there are 5 reasons for a decision, or 6 or 7, doesn't matter. One of them is an important ground and it is bad for whatever reason, because it failed to take into account relevant considerations or anything else, the whole decision goes by the board. There's a related principle, milady, which is reflected in the very next sentence in Rustenburg-Platz, and it is this. The same applies where it is impossible to distinguish between the reasons that substantially influenced the decision and those that did not. So where you have, take the example of 5 reasons for a decision, and you cannot conclude from the decision itself which ones were regarded by the decision maker as the ones which resulted in the actual decision. In other words, the decision maker doesn't indicate which ones substantially influenced the outcome. The product is the same. The entire decision goes by the board. Milady, that principle was more recently reiterated, and if I could just give you the reference, it's not in my note. It's the case of Westinghouse Electric versus Eskom, and it's reported in 2016, volume 3 of the South African Law Reports, page 1, SCA. And milady, it's at paragraphs 44 to 45. In 44, they quote the passage from Patel, which I've just read to you. And in paragraph 45, they refer to its acceptance by the court in Rustenburg. And they conclude by saying, once a bad reason plays a significant role in the outcome, it is not possible to say that the reasons given for it provide a rational connection to it. And so, milady, that is a well-recognized instance of acting unreasonably. As I've indicated, it features in Baxter's chapter on acting unreasonably. Milady, there is a third ground which I accept immediately is a more recent development in our law. And it is one which we respectfully rely upon. That is, it is now well established, and your ladyship knows this very well, because I found a judgment in which your ladyship referred to the principle, and that is that where a decision maker gives reasons for his or her decision, the decision maker is bound by those reasons and cannot rely on ex post facto reasoning. Now, milady, we set out those heads. It goes back to the National Lotteries Board case that's in our heads, and I've given you the reference. Milady, in case your ladyship needs reminding, where your ladyship accepted it, your ladyship did so in a case called Fourie Fisma Inc. versus the RAF. It's actually now reported, it's in 2020, volume 5 of the South African Law Reports, page 465, and your ladyship accepted that principle at paragraph 66. Now, milady, we make that point because of something we submit which is quite remarkable in the present context, and that is that you have been presented with a document called an explanatory memorandum. And if I may be permitted to use the language that Vodacom used in relation to Mr. McCarthy's idea, I would respectfully submit to your ladyship that it must be something of a world first for an explanatory memorandum running to some 105 pages to be 5 times longer than the actual decision itself. Now, we submit, and my learned friend Mr. Pakran will deal with this in due course, is that that's not acting reasonably. You can't ex post facto provide an explanation 5 times as long as the actual decision itself. A decision maker is bound by the reasons given at the time of the decision. And that's for very good reason. It's to obviate, as the SCA has pointed out many times, the notion of ex post facto reasoning. It means that the reasons given after the event are not, in fact, the reasons for the decision. So, milady, in a nutshell, if your ladyship were to find that the CEO acted as an expert valuer, there is ample room in our law for the reviewing and setting aside of his decision. But, milady, importantly, we submit that the parties at the beginning of the proceedings in front of the CEO, in fact, adopted a broader standard, and they did so by agreement. Brings me to my fifth category, my fifth topic, and that is the standard which Vodacom and the CEO accepted. And, milady, it really all started at the beginning of the hearing, where this debate took place about what function the CEO was to perform. And I had indicated in my submissions to the CEO that the actual label was less important than the manner in which the CEO went about his job. And Vodacom had in their heads of argument proposed a formula, and I'm going to quote it to your ladyship. It's in the references in 5.1.3 of my notes. Vodacom suggested to the CEO the following. They said, and I quote, "In Vodacom's view, you are required to do no more than to act in an objective manner, relying on your experience and applying your mind fairly and reasonably so as to ensure that your determination neither results in a manifestly unjust nor a patently inequitable outcome." Now, your ladyship will immediately see that that is a more expansive test than the test for a valuer. It's expansive, more expansive in at least three respects, possibly four. First of all, the standard which is set is an objective standard. It's not simply the mere opinion, subjective opinion. It's an objective standard. The second is, and perhaps this is not anything new, is that the decision maker has to apply his or her mind fairly and reasonably. So the requirement of fairness in addition to reasonableness is included. And lastly, it must not result in simply a patently inequitable outcome. It must also not result in a manifestly unjust outcome. Now, it may be that that is a distinction without a difference. I don't place too great a store on it. I merely stress that this was the standard, not simply proposed by Vodacom, but it was accepted as the appropriate standard by Mr. McCarthy, and perhaps more importantly, or equally importantly, it was accepted by the CEO himself. And your ladyship will know that it was so accepted by the CEO because he says as much explicitly in his determination, in paragraph 4 of the determination, and indeed our learned friend for the CEO accepts as much in his heads of argument, which are before your ladyship. So, the lady, it is, of course, extremely well known that bear in mind that we are dealing with a contract, and the contract is between Mr. McCarthy and Vodacom. They are the contracting parties, and they are entitled by their conduct, or by their conduct even of the submissions to the CEO, to vary that contract or the terms of reference. That is a principle which goes back again many, many years to Schill versus Milner. And milady, we've given you the reference in our heads, but perhaps I should just indicate to your ladyship what the AD, as it then was, said in Schill versus Milner at page 105. They quoted from, indeed, a case which is now 100 years old, also in the AD, the case of Weinberg versus Dreyer. And at page 105 of the judgment, they say this: in another case, Weinberg Municipality versus Dreyer, 1920 AD, an attempt was made to confine the issue on appeal strictly to the pleadings, but it was pointed out by Innes CJ that the issue had been widened in the court below by both parties. And then they quote, "The position should have been regularized, of course," said he, "by an amendment to the pleadings. But the defendant cannot now claim to confine the issue within limits which he assisted to enlarge." And that's exactly what is happening here. Vodacom, to use this terminology, assisted to enlarge the manner in which the CEO was to fulfill his function. The other contracting party, Mr. McCarthy, agreed, and the CEO himself adopted that standard. So, lady, we would submit that if we are correct on the reviewability, even under the valuer standard, it is all the more so under the expanded standard agreed to by the parties. Now, your ladyship will be assisted in that regard by the judgment of Justice Colopin in the interlocutory proceedings in this very matter. Now, our learned friends for Vodacom cavil against the suggestion that the judgment of Justice Colopin is of any use to your ladyship at all. They constantly describe that judgment as merely interlocutory, or in their words, entirely ancillary to the main review, and did not dispose of any issue in the main case. Again, milady, I've given you the references to their heads of argument. Milady, the attempt to escape the judgment of Justice Colopin is respectfully of no avail. I do not wish to detain you, your ladyship, as we have in our heads of argument, with arguments as to whether this is res judicata or whether it gives rise to an issue estoppel. I put that all aside and I make a simple submission to your ladyship, is that your ladyship will find that judgment useful at the level of its persuasiveness, that your ladyship will properly have regard to it for its persuasive value, not necessarily that your ladyship is bound by it. And let me explain why. Justice Colopin had to face a threshold issue. Bear in mind, he was faced with an argument which sought the compulsion of documents which Mr. McCarthy said were relevant to his review. And Mr. McCarthy, as your ladyship knows, invoked Rule 53 for that purpose. But there was a threshold question that Justice Colopin had to answer. And that was whether or not the court had jurisdiction to review the matter at all. Your ladyship, I can see, knows it. And that, of course, flowed from the Constitutional Court decision in Competition Commission versus Standard Bank, which directed that the threshold question had to be decided up front. And milady, it was an identical case to the one before Justice Colopin. That case, too, was an attempt to compel the production of documents under Rule 53, as was the case in front of Justice Colopin. So it's in that context that he had to answer certain critical questions. And he did so by reference to well-established authority within our law dealing with the reviewability of contractual terms. And as your ladyship knows, there is nothing new about the reviewability of contractual terms. It goes back many, many years, probably 100 years as well. And milady, it's in that context that your ladyship will find, at a minimum, and I don't want to overstate the position, your ladyship will find helpful and persuasive what Justice Colopin did or said in paragraphs 36 to 41 of his judgment. And perhaps I could just highlight aspects of what he said. In paragraph 36, milady, he said, the stance of the second respondent is that the applicant was not entitled to review the determination of the first respondent, as it does not constitute an administrative decision subject to judicial review, as the first respondent acted as a private adjudicator and was not exercising a public power. If I could pause there. The stance adopted that this was an unreviewable decision. And then his lordship referred to the Jockey Club versus Forbes, and he said in paragraph 38, it is not in dispute that even though the first respondent was not exercising a public power, he was required to apply the principles of fairness and reasonableness, and that the procedure that he put in place and followed allowed the parties the opportunity to make both written and oral submissions in appearance before him. And he then says, under these circumstances, it hardly matters what designation was given to the first respondent, deadlock breaker or private adjudicator. What matters is that he was required to exercise a power in accordance with the principles of fairness and reasonableness and in a manner consistent with the principles of natural justice. That is exactly what we urge upon your ladyship today, and we will submit that your ladyship will be assisted in that regard by that judgment. But the lady, may I make this absolutely clear? There is nothing startling or revolutionary about what Justice Colopin found. And I go back to Baxter, my lady, and bear in mind that what I'm about to give your ladyship, and it's in my note, was written in 1984. And my lady, what Baxter said in this regard appears at 101 of Baxter under the heading private or contractual bodies. It's exactly the situation with which your ladyship is concerned. And this is what he said. He said, even if it is decided that an institution is private and not public, the result might not be substantially different. As a general principle, any private institution which exercises powers over individuals is obliged to observe common law requirements which do not differ in principle from those applied to public bodies. Thus, the courts have always been prepared to review the decisions of private or domestic bodies, such as the disciplinary tribunals of churches, trade unions, or clubs, and even the decisions of arbitrators. Although the basis upon which the powers of these bodies rest is contractual and not statutory, such bodies are often in a position to act just as coercively as public authorities, and their decisions frequently have far-reaching effects. Many of the principles of administrative law are designed to protect individuals from abuse of power. For this reason, they are applied in almost identical form to those private bodies, and administrative law has itself drawn much from decisions involving domestic tribunals. Cases involving the exercise of power by both public and private institutions are often cited interchangeably in the courts. So, my lady, there is truly nothing novel or surprising by the proposition we advance and which was accepted by Justice Colopin. Can I then turn, my lady, finally in this regard, before saying something about remedy, to how the matter has been treated in England. And your ladyship will know that it is not unfair to say that our administrative law has been massively influenced by English administrative law, which is constantly pre-constitution and post-constitution cited with approval by our courts. And, my lady, the case is referred to in our heads of arguments. It is the recent or relatively recent Supreme Court decision in Braganza. And, my lady, not only does your ladyship have the decision, but it's also been uploaded onto case lines. Lady, what happened in Braganza, and can I just preface what I'm about to say, is that our case, the one before your ladyship, is a much stronger case than Braganza for reasons which will become apparent in a moment. What happened in Braganza was that the claimant's husband had been an employee of BP Shipping, and he had been employed on one of these oil rigs, and he disappeared. It was thought that he might have drowned or fallen off the rig, and the question at issue was whether his widow was entitled to receive certain benefits flowing from his death, but which would not be available to her if he had been found to have committed suicide. So he had a contractual entitlement to these benefits unless his employer formed the opinion that his death resulted inter alia from suicide. And the employer therefore had to, in terms of this contract, had to perform a fact-finding role, the result of which could deprive his estate of a benefit to which the estate would be otherwise entitled. And it was an inquiry into the circumstances in which he apparently lost his life. Now, milady, I say that ours is a stronger case because if you have regard to the contractual provision that was in issue in that case, you will immediately see why. Milady, that contractual provision is reflected in the judgment of Lady Hale, who wrote for the majority in that case in her opening paragraph. And for case lines reference purposes, milady, you'll find that at 140-43. And the contractual clause said this: for the avoidance of doubt, compensation for death, accidental injury, or illness shall not be payable if, in the opinion of the company or its insurers, the death, accidental injury, or illness resulted from, amongst other things, the officer's willful act, default, or misconduct, whether at sea or ashore. So the standard in the contract was in the opinion of the company or its insurers. Now, we don't have that because it's accepted in this case that the inquiry is an objective one. It is not confined to the subjective opinion of the CEO. And, milady, dealing with Lady Hale's argument, can I take you to paragraph 18 of her judgment? And it's at case lines 140-49. She says this: contractual terms in which one party to the contract is empowered to exercise a discretion or to form an opinion as to relevant facts are extremely common. It is not for the courts to rewrite the parties' bargain for them, still less to substitute themselves for the contractually agreed decision maker. And here's the important sentence: nevertheless, the party who is charged with making decisions which affect the rights of both parties to the contract has a clear conflict of interest. That conflict is heightened where there is a significant imbalance of power between the contracting parties, as there often will be in an employment contract. That is a textbook example of what we have here. The CEO is, of course, the CEO of Vodacom. He has to make a decision in relation to money which his company, of which he is the CEO, is to give to Mr. McCarthy. And the contract certainly arose at a time when there was a massive imbalance between Vodacom on the one hand and Mr. McCarthy on the other. And her ladyship goes on to say, the courts have therefore sought to ensure that such contractual powers are not abused. They have done so by implying a term as to the manner in which such powers may be exercised, a term which may vary according to the terms of the contract and the context in which the decision-making power is given. Her ladyship then goes on to do an exhaustive survey of the law up until that point, and then at paragraph 24 she comes back to the case I said to your ladyship I would return to, Wensbury Corporation, the Bible of English administrative law, and she does so at paragraph 24 of her judgment, where she says this. She says, the problem with this formulation, which is highlighted in this case, is that it is not a precise rendition of the test of the reasonableness of an administrative decision, which was adopted by Lord Green in Wensbury. His test has two limbs. And then she quotes from the case, the court is entitled to investigate the action of the local authority with a view to seeing whether they have taken into account matters which they ought not to have taken into account, or conversely have refused to take into account or neglected to take into account matters which they ought to take into account. Once that question is answered in favour of the local authority, it may still be possible to say that, although the local authority have kept within the four corners of the matters which they ought to consider, they have nevertheless come to a conclusion so unreasonable that no reasonable authority could ever have come to it. Exactly the mirror image of what Baxter was describing when he dealt with both the basis of the decision and the effect of the decision. And then her ladyship in paragraph 28 says there are signs that the contractual implied term is drawing closer and closer to the principles applicable in judicial review. And her conclusion is really reflected in paragraph 29 and 30. It's at case lines 140-54, where she says this: it is part of a rational decision-making process to exclude extraneous considerations. It is, in my view, also part of a rational decision-making process to take into account those considerations which are obviously relevant to the decision in question. It is the essence of Wensbury unreasonableness review to consider the rationality of the decision-making process rather than to concentrate upon the outcome. Concentrating on the outcome runs the risk that the court will substitute its own decision for that of the primary decision maker. And here comes the crunch. It is clear, however, that unless the court can imply a term that the outcome be objectively reasonable, for example, a reasonable price or a reasonable term, the court will only imply a term that the decision-making process be lawful and rational in the public law sense, that the decision is made rationally as well as in good faith and consistently with its contractual purpose. For my part, I would include both limbs of the Wensbury formulation in the rationality test. Indeed, I understand Lord Neuberger at para 103 of this judgment, and I to be agreed as to the nature of the test. So, milady, that's Lady Hale. Although there was a division in the court, everybody was agreed on the test. So let me take what Lord Hodge said, and your ladyship will find that at case lines 140-60, it's at paragraph 53. He says this: like Lady Hale, with whom Lord Neuberger agrees on this matter, I think that it is difficult to treat as rational the product of a process of reasoning if that process is flawed by the taking into consideration of an irrelevant matter or the failure to consider a relevant matter. While the courts have not as yet spoken with one voice, I agree that in reviewing at least some contractual discretionary decisions, the court should address both limbs of Lord Green's test in Wensbury and milady Lord Neuberger at paragraph 103, and your ladyship will find this at case lines 140-74. Like Lady Hale, I consider that there is considerable force in the notion that this approach is, and at any rate should be, the same as the approach which domestic courts adopt to a decision of the executive as described in the judicial observations which she quotes, and as reflected by the reference to the Wensbury decision in the passage. So, milady, that is the position as it is now in English law. That is the position which Baxter suggested has at least been the position in our law since 1984, but if one has regard to the cases to which he refers, it goes back a very, very long way. Now, milady, we would suggest that that really is determinative of the standard which your ladyship will apply, because the parties have agreed to that standard in this case. But, milady, assume that I'm wrong even in that regard. Your ladyship is perfectly entitled to, and will, of course, develop the common law. And I address that in two different respects. I address it in the way in which the common law was developed under the common law, in other words, prior to the Constitution. So I'm not making a constitutional argument at all in the first instance. And your ladyship will see that in our notes at paragraph 5.5, we have referred to the manner in which the common law develops at common law by reference to what has been said now really dozens of times by our courts, and where they refer to Pearl Assurance versus the Government of the Union of South Africa, where they referred to where he referred to the common law as, and I quote, a virile living system of law, ever seeking as every such system must, to adapt itself consistently with the inherent basic principles, to deal effectively with the increasing complexities of modern organized society. And that's what our courts have done repeatedly and constantly for generations now, milady. Of course, under the Constitution, your ladyship has the power and the duty to develop the common law should the need arise. We refer also, milady, to the recent pronouncement by the Constitutional Court in Biadica. Again, I've given your ladyship the reference in 5.5, and it's simply to this, where the Constitutional Court emphasized that transformative adjudication requires courts, and I quote, to reach for substantive justice, which is to be inferred from the foundational values of the Constitution. So, milady, if your ladyship believes that we are overstating the position and that the standards that we are urging upon your ladyship require some sort of development, then your ladyship has both the tools to do so, and we would respectfully submit the obligation to do so. That leads me then to my final point, and because I'm making a brief guest appearance in this case, it is out of sequence, because I want to say, and very briefly, make some submissions to your ladyship about remedy. The lady, it assumes, of course, that your ladyship will find in favour of Mr. McCarthy. And incidentally, my lady, there is no debate between us and Vodacom that the decision is reviewable. The debate, the crunch, as your ladyship put it, is the standard of review or the basis of review. Not that it is unreviewable. They accept that it's reviewable. So if your ladyship were to find in Mr. McCarthy's favour, the big question is what is to be done. Now, my lady, let me say immediately that we are alive to the fact that substitution is regarded as an exceptional remedy. And again, your ladyship, I know, has given judgments in that regard, so I don't need to persuade your ladyship. We proceed upon an acceptance that our attempt to persuade your ladyship to give a remedy of substitution is exceptional. May I submit to your ladyship why we submit that the test of exceptional circumstances is met in this case. And we say so for three reasons. The first, milady, is the sheer history and duration of the matter. The history is an unfortunate history. I've taken some time to indicate to your ladyship just how unfortunate that history is. But the saga has now been going on for more than 20 years. And what we see at every turn, including in these proceedings, is an unstinting endeavor by Vodacom either to deprive Mr. McCarthy, as they did at trial, to any entitlement at all, or as we saw in the negotiations and in the adjudication by the CEO, to leave him with the absolute minimum possible, quite unrelated to the contribution that his brilliant idea assumed. So our first point is the unfortunate history, the length of time, and the need for the matter to be brought to finality. The second point, milady, is that what we are concerned with here, as Lady Hale pointed out in the passage to which I have referred, is that where one of the parties to the contract enjoys this decision-making power, there is an inevitable conflict of interest. And so it is with the CEO in this particular case. And while we, of course, accept that that conflict of interest is a consequence of the perhaps naive deal which Mr. McCarthy struck with Vodacom, we submit that it is simply no longer fair to expect of this CEO to once again embrace the matter in which he is conflicted. And the third point we make, milady, and it's related to the previous point, is the manner in which Vodacom and the CEO have conducted themselves in these very proceedings. Even if we assume, for present purposes, that the CEO is entitled to put up an explanatory affidavit, it is, as I've indicated, something of a world first. And that explanatory affidavit is 5 times as long as the very decision which is in issue here. And this comes from a party who said that he would abide the decision of the reviewing court. And what we would submit, milady, is that it would be quite inappropriate to send this matter back to the very person who has shown this level of determination to defend the indefensible. So, milady, we submit respectfully that substitution is appropriate in this case, but assume we are wrong. Assume that your ladyship is against us on the remedy. Then in the alternative, milady, we would submit that against the background which I have set out in some detail, we submit that a simple remittal to the CEO would be inappropriate. What we would submit is that if your ladyship is so inclined that the matter is remitted to the CEO, then your ladyship would do so with very strict guidelines as to the manner in which the CEO is required to exercise his powers. For example, and milady, let me say to you immediately, we will put up in due course a draft order in relation either to substitution or alternatively for remittal together with clear directions. What your ladyship would do, we would submit, if your ladyship opts for remittal with directions, is to make it absolutely clear, for example, that the duration for which Mr. McCarthy is entitled to a reasonable remuneration is, on our argument, 18 years, that he is entitled to interest at whatever rate the case may be. I don't want to anticipate all the options. I merely indicate to your ladyship is that we would be inviting yet another round of extensive litigation if we simply leave this to the open-ended discretion of the CEO, and we would therefore submit that the proper thing to do in the event of remittal is to give the CEO guidelines as to how he must perform his function, but we will submit a draft order for your ladyship's consideration.
But Mr. Marcus,
yes,
would I not now be entering into the realm of creating the contract for the parties if I'm going to dictate and say that the calculation should be, in terms of the share revenue, should be for 18 years, that the interest should be at 15%? Would I not be then dictating the contract for the parties in that sense? And then what function would the CEO be performing in terms of reaching a determination that he was assigned to do in terms of the Constitutional Court judgment?
Take your ladyship's point. Milady, our submission to your ladyship would be this. This would not be a situation in which your ladyship would be making a contract, because what your ladyship would be doing would be simply laying down the manner in which the CEO is required to make the determination. Let me take a simple example, if I may. And again, it's for my learned friend, Mr. Puckrin, to address your ladyship in the... Let us assume that your ladyship were to find that using the model of an employer-employee contract was taking into account an irrelevant consideration. Just assume that for present purposes as we submit. If your ladyship were to remit this to the CEO, your ladyship would be perfectly entitled to indicate in the remittal that the CEO was not entitled to have regard to employer-employee contracts for the purposes of determining a reasonable share of the revenue generated. That is precisely what Justice Coppin found. The CEO, for reasons which are not clear, seems to have thought differently. Now, I use that simply as a clear-cut example. We will endeavour, milady, to avoid the very point that your ladyship makes. And we will endeavour to formulate the kind of directions for remittal which do not impinge upon the contract-making function, but rather relates to the manner in which the CEO is required to exercise his powers.
Thank you, Mr. Marcus. Yes, continue.
Milady, I'm actually finished.
Are you finished?
Yes.
Who's dealing with the aspect of costs? Not you.
Milady, my work is done. But milady, in fact, it is so done that in fact, for all sorts of reasons which I won't go into, I need to ask your ladyship if I may be excused. One of my other learned friends will do the reply, but I'm afraid for all sorts of reasons, this is genuinely a brief guest appearance by me. And I certainly thank your ladyship for the pleasure of doing so. But I do need to ask your ladyship if I may be excused.
Not a problem. It would seem everybody needs to basically pitch in and earn their fee, basically. That's basically what it means.
It's exactly what it means, milady.
Thank you, Mr. Marcus. You are then duly excused, and whoever will be doing the reply, I will deal with them with any questions thereafter. Thank you for your attendance, and you're excused.
Thank you, milady.
Keep safe. Mr. Puckrin?
Thank you, milady. Milady, I've said so before, after addressing the court after Mr. Marcus has, and let me say that I don't believe your ladyship will listen with much enthusiasm to the overture after you've heard the whole symphony, but I shall do my best. Milady, whilst my learned friend has concentrated on important issues involving the legal framework within which this review should take place, the task falls upon me to deal largely with the facts. And in so doing, may I say we have filed, as indeed have our learned friends, comprehensive heads, yes, but it seems to me that it is with respect to dead letters, just simply to read through those heads. We don't, of course, abandon anything in the heads. I shall be reverting to the heads after doing my primary task, which I shall define in a moment. My primary task defines itself. In a review of this nature, the true protagonists and antagonists are obviously the decision maker on the one hand, and the party who feels aggrieved by the decision. In this case, obviously the CEO and Mr. McCarthy, who has alleged a number of irregularities, call them what you will. Vodacom plays, with respect, somewhat of a inferior role, because although it might support the CEO in his determination, what they can't do is in any way bolster his determination with new reasons, new arguments, and new thoughts. Clearly not. So I intend to concentrate, to begin with, on the dispute between Mr. McCarthy and the CEO in respect of his determination. Now, to avoid a staccato approach, whereby I go to the irregularities and then ask your ladyship to look at a particular passage in the determination, I think that it might be salutary to start at the beginning of the determination and continue as far as I need, and try and identify at each juncture where we say the CEO went wrong. In order to do that, though, I need to do two things to simplify the task. And at the risk of being puerile, I have compiled a formula which at the end of the day was what the CEO had to determine, and upon which your ladyship now sits in judgment. And if I may ask somebody who is more digitally able than myself to call up the formula. I have it. Does your ladyship have it? It's at 141-1.
141-1. There you are. Yes.
Now, it's very simple, in fact. It's not a complicated equation. It is a simple formula with obviously certain functions. It is the functions that I think are the problem and that are in dispute, but not the formula. There may be other ways of phrasing it. But the formula for revenue generated by PCM. Now, the revenue that I've deliberately used the word revenue. I am acutely aware that, of course, the revenue may be divided into total revenue and incremental revenue, but at least for determining revenue generated by PCM, which we call the McCarthy share, over any selected period. Now, that, of course, is one of the disputes, which is why it's in red. The McCarthy share equals 5%. Now, there's no dispute about the 5% between the CEO and ourselves, even at the stage of the submissions, and the CEO has adopted the 5%. The 27%
yes.
is the 1 hour window. You will bear in mind, when one reads the evidence of Mr. Zatkovich, he had no difficulty, and let me say his evidence was absolutely uncontroverted, that the way to sift the grain from the chaff, that is to select the incremental revenue, is to select a window. Obviously, as a matter of logic, and of course as a matter of elementary statistics, the closer to the PCM being dispatched, the recipient gets a call, on the probabilities, it has been triggered by the PCM. So you can select any window, but I will show you when we get to the determination, the CEO has accepted the 27%, although what he does to it, with great respect, is he mutilates it at the end, and I'll show you why. Then that is multiplied by the please call me cent, and by the average duration of the call, and then the effective rate, the money. And that will give you what has to be, what the CEO had to decide. So it's not as though this is a matter of great algebraic complication. It's fairly simple. So that's the first issue that I need to debate with you, or at least not debate with you, but show you. The second issue that I must explain to you, which quite frankly I personally was not aware of, and I'm sure perhaps your ladyship would have been aware of it, is that the Vodacom total voice revenue, excluding data and SMSs and the like, may be expressed as follows. First, there is the prepaid revenue. Now, we all know about the prepaid, you buy your airtime. There is then, secondly, the MTR, which is the termination rate. Your ladyship will be aware, and I'm sure that the Vodacom representatives who hear me will wince, but let me say it, it's my sentiment. The companies have cozily entered into an agreement where if a call is initiated from one network, or for that matter Telkom, and terminates with Vodacom or Mnet, they get paid a certain amount, a rate which is set by ICASA. That's called the mobile termination rate. That is money which is earned by, in this case, Vodacom from the termination, even though it's not from a Vodacom phone. Then the third category of income or revenue is from contracts or subscription. Now, here there is a dispute, and I will demonstrate to you how this is developed and how, with respect, Vodacom got it wrong, and certainly the CEO got it wrong. When one enters into a contract, there are, of course, innumerable bundles of voice and data that one can purchase. I'm sure your ladyship knows this well. But insofar as the voice component of the contract is concerned, you can contract for, let's say, 1,000 minutes or 200 minutes, 500 minutes. When that is at a particular rate. When you have come to the end of your so-called bundle, until then, it is what is called in-bundle revenue.
In-bundle
when you come to, yeah, when it's up, you're out of bundle, and boy, do you pay. Then you pay. Absolutely, you pay. So that, my lady, is how they earn their money. By the way, we exclude from this, and we must. We exclude international calls. We exclude roaming. We exclude the advertising on the SMSs, and I think we also exclude any revenue earned by Vodacom Group subsidiaries in the rest of the world. We are dealing only with South Africa. So that then is important, because we're going to demonstrate how this has played out its role in the CEO's determination. Now, lady, may I ask you to take up the CEO's determination, and it's to be found at case line 0041. He has, does your ladyship have the have the case line references on the hard copy?
Yes, 004-4.
I just wanted to know to which number I should refer. He's got on 0043 abbreviations which speak for themselves and I don't think are very important. Now, he deals in paragraph 1 with the facts. We have no great quibble with the facts. In 1.6.1, we point out that the CEO is acutely aware of the fact because he actually accentuates the part which one finds in the order of the Constitutional Court. Vodacom is bound by the agreement concluded by McCarthy and Geisley, as testified to in the High Court. Now, that's absolutely correct, and it is the agreement which is alluded to by Justice Jaffna at paragraph 5 of the Constitutional Court judgment, and my learned friend Mr. Gilbert has dealt with that in great detail. And then 1.6.2, Vodacom must commence negotiations in good faith with Mr. McCarthy for determining a reasonable compensation payable to him. Let me pause there. That reasonable compensation is not a rudderless ship. As a matter of interpretation, that reasonable compensation is in terms of the agreement. And the reason I mention this is because Vodacom have consistently, and I say with studied obtuseness, if I may, contended that all that the order said was that Mr. McCarthy should be paid a reasonable compensation, just not the way you interpret this order. And then the costs and the negotiations. Then in paragraph 2, the CEO deals with the negotiations. And I don't believe there's anything at page 004-5 other than to suggest that it is a rendition of the history. And then at 004-6, the CEO again. Now, the referral to the Chief Executive Officer in 3, and my learned friend, Mr. Gilbert, Mr. Marcus, has, of course, yes, I'm sorry, familiarity does breed contempt. He says that the deadlock breaking function would preclude you from participating in the negotiations, and they made written submissions. They also made oral submissions to me expanding, and then he mentions in 3.6 a point, of course, which your ladyship pointed out, that he required legal assistance, to which neither party had any objection. And then in 4.1, in the written submissions, McCarthy described my function as that of an arbitrator, and Vodacom described my function as that of a valuer. Well, you've heard that argument, and he ultimately was content to regard himself as a deadlock-breaking mechanism.
Yes.
And in 4.2, the quotation there was, in fact, from Wright versus Wright. And he says this: I also bear in mind that I was appointed to perform this function by reference to the office which I hold. This, I think, suggests that the parties anticipated that the deadlock breaker would be familiar with Vodacom policies and processes followed in product development, as well as the assessment of monetary compensation for services related thereto, including the development of products from an original idea. Now, I want to just stop there for a moment. The parties, of course, are Mr. McCarthy and, in truth, Mr. Alan Knott Craig. This was not a choice in 2018 by Mr. McCarthy and Vodacom to select specifically Mr. Jewson. And that is important because Mr. McCarthy, as my learned friend so eloquently said, Mr. Marcus, it might have been the naivety on the part of Mr. McCarthy, who really had no option but to trust Alan Knott Craig. And I must tell you that his evidence was that he had the highest regard for Mr. Knott Craig. And how that... So I just want to be absolutely sure that one does not here believe that this is a 2018 appointment. This is a historic appointment, which unfortunately Mr. Jewson had to be troubled with because he had been the successor after, I think, 2 other CEOs at Vodacom. Now, he says in 5, the difference of approach between the parties. The parties repeated their standpoints which had emerged during the initial negotiations, and so the models which they had advanced for my consideration had very different points of departure, and that's the understatement of the, or at least of the decade. Whilst I will deal with both models because they each have value in giving some perspective, let me stop there immediately. The agreement is quite clear. It is quite clear. It is a share of the revenue generated by PCM. Now, how the model of an employer-employee relationship can give any perspective to that agreement, or how that model can in any way contextualize this agreement a la Indomini, is beyond my ken. I cannot perceive of how the employer-employee relationship has any bearing on it. And milady, whilst we're dealing with that, I would like perhaps to suggest that the sarcophagus of the employer-employee relationship model be buried for once and for all. It comes up time and time again. There is a dirge in the papers even after this determination about employer-employee, and we have frontier economics opining on it. I want to just go a little further than my learned friend Mr. Marcus did about it, because having been there and having had to amend the pleadings, my learned friend Mr. Micho, we can tell your ladyship what happened, and it's all in the court record. Vodacom had pleaded that Mr. McCarthy, in terms of the common law, did not own the inventive rights to PCM because he was, because they invented in the course and scope. That's the common law. And the common law impinges on patent law. The Patents Act is silent about that. Now, of course, there's no doubt he was employed by Vodacom. But what blew the scope sky high was Mr. Andrew Mthemba's pronouncement in talk time that what makes this so remarkable is that Mr. McCarthy was not employed in product development, but in fact was employed in the financial department. Now, that means he could never have invented this in the scope of his employment. And so in terms of our South African common law, Mr. McCarthy was the owner of that invention. If he had wanted to sell the IP to anybody, Vodacom could never have prevented him. If he had wanted to patent it, and Mr. Zatkovich says it was a patentable idea, he could have patented it. Why it is important with respect is to mention that Vodacom abandoned that plea altogether. They abandoned it. And then, of course, that was a sensible decision by my late friend, Mr. Salier. Now, having abandoned it, it seems to us to be an absolutely hopeless, wasteful, and quite frankly misleading exercise to bring a German expert who opines on a German statute which deals with employer-employee inventions, particularly made in the course and scope of their employment. Now, what has happened is the German law, because there are endless disputes worldwide when patents are involved or intellectual property is involved, as to whether or not, what often happens, my lady, if I may just tell your ladyship, often happens is a man conceives of an idea. Now, if Mr. McCarthy, for instance, had been in the product development division under Mr. Geisler, had conceived of this idea and then silently left the employment of Vodacom and gone to MTN, that would have been dishonorable. Now, this often happens worldwide. And so the Germans have decided, well, there's only one way to do it. Let us just legislate for it. And we legislate a fair compensation if you invent within the course and scope of your employment. This is all dealt with in a memorandum by Mr. Charles Newpin, which is in the record somewhere, who did some research on it for the purposes of the negotiations. So, milady, that is the end of the matter, and one should not entertain any thought of it because it can only blur the picture. And what it does here is it permits the CEO somehow to introduce this model into one of the four that he considers, and he says purely for comparative reasons, but with respect, it may cloud his vision, and we believe it has. Assessment of the McCarthy model. Now, milady, this is of fundamental importance to our case, because if I am correct in my assessment of what happened here, there has been an understatement of the incremental revenue of which Mr. McCarthy is entitled to, we agree, a 5% share, by some 70%. And I'm going to demonstrate that, not doing all of the figures, because my learned friend Mr. Michal will do that, but I'm going to establish the principle. Now, you will see that a final submission on behalf of McCarthy, entitled Response to the Vodacom CEO, was made subsequent to oral hearings, which present the Model 8A, and that's in the ANZ report. The report tracks its estimates of the PCM revenue year by year.
Yeah.
Now, look at 6.3. It's very important. I draw attention to fundamental aspects of Model 8A, and in particular, the calculations of voice revenue on which the model is based. I point out that those basic estimates need to be carefully examined, because if they are inconsistent with the publicly available financial data, the model would be discredited. His language. Now, of course, if Mr. McCarthy's model is discredited, that's the end of the matter, then the CEO is at large to build his own model. And Mr. McCarthy's model is dismissed, which is exactly what happened. Now, I want to just read a 6.4 carefully to your ladyship, because this is the ipsissima verba, obviously, of the CEO. I have contrasted those figures, 8A, with the financial information provided by Vodacom. Now, may I say that that was provided by Vodacom after the submissions in a letter by Leslie Cohen and Associates in volume, well, I'll find it for you in a moment. I am going there. It was post the submissions at the request of the CEO and at the request of my instructing attorney on behalf of Mr. McCarthy. But let's continue. Showing its voice revenue. Now, voice revenue there is unqualified. One must assume it means total voice revenue, because he goes on, i.e., the income generated when a Vodacom mobile customer receives a call from a user on Vodacom. May I stop there? Obviously, the income is not the reception by the Vodacom mobile customer, but the making of the call by the user on Vodacom, clearly. Then, this is of fundamental importance, or another fixed or mobile network. Now, that can only refer to MTR, because if a child sends a PCM on a Vodacom phone to his mother or father who has an MTN subscription, of course, the return call to the child will generate MTR for Vodacom, or for that matter, Telkom. So what it appears to be is that Mr. Jusub called for voice revenue, and that was all the income generated from a Vodacom call to a Vodacom mobile device, or the MTR from another station. It's as simple as that. I'll come to the table in a moment, but I want to now demonstrate to you what was requested, and it's volume 13. My attention is being drawn by hungry people all around me that I'm intruding on your ladyship's time. Would this be an appropriate moment?
Yes. What is the volume that you're going to, so that I can have that on hand when I get there?
Well, we have different volumes, but can I just tell you, it is it's bundle 13, 0101 and following.
Bundle 13.
She also had bundles.
Yes, I have bundles. I have bundles, Mr. Cochrane.
Well, then it's much easier. We can talk to each other, my lady. Thank you.
Right. We will now take the lunch adjournment and can resume at 1:45 instead.
Absolutely, my lady.
Right. So we will now take the lunch adjournment. Court's adjourned.
She said she lost that MTR just quickly.